I just went on my data. We'll see if that's better. See if anybody pops in here. All messages. And so we're going to go through basically everything that I got going on, and give a quick little rundown on some of the results of like the reasonableness of the tow hearing. I got that right here. And a number of other things. Let me see, make sure. Put this up like that. There we go. All right. And we're also going to cover the lawsuit, the appeal, the return of my stolen phone by Homeland Security. Look in the comments, or the description rather. It gives a little rundown here. The fine payment hearing that I got coming up. The contempt situation and all the complaints that I filed the other day, the temporary restraining order. And so, yeah, so let's just get right into it. What's up, Rob? How's it going? The first thing that I'm going to read here is the reasonableness of the tow hearing results, right? So this is from, what's that guy's name? Daniel Sklut, S-K-L-U-T. And he says, "Dear Mr. Staples, I'm writing regarding your tow hearing pursuant to RSA 26233 held on Wednesday, August 6th at the Dunbarton Town offices. I was designated by Chief Remillard to conduct the hearing. The scope of my authority under Section 2 was to determine whether there was sufficient grounds for towing your vehicle. No, it was to determine the reasonableness of the tow. Reasonableness, not whether there were sufficient grounds. It was whether the tow was reasonable. After listening to your presentation, reviewing New Hampshire RSAs, reviewing Dunbarton police policy, and considering citation number 340270, which was the rebuttal, even though the officer never rebutted, he took the citation as a rebuttal and did not allow me to cross-examine the officer about the citation. He says, I have decided that there were sufficient grounds to tow your vehicle. The summary of my reasoning for reaching this conclusion follows. Concord Stage Road, where you were stopped, is a state highway owned and maintained by the state of New Hampshire. RSA 26140 requires that it is generally a violation for any person to drive a vehicle on the ways of this state unless it has been registered and the appropriate fee paid in accordance with the provisions of this chapter. And it doesn't allow for your vehicle to be towed. It's a ticket. It's a $100 ticket. That's it. And there's nothing in 26140 that allows for the towing of a vehicle. Based on a review of the citations issued to you that day, a motor vehicle summons was issued to you due to a lack of valid registration of a motor vehicle that you were operating at the time of the stop, and that you confirmed is your vehicle at the hearing identified above. During your presentation, you referred to distinction between the definitions of previously registered, citing 259:79, and unregistered. You also referred to exemptions of previously registered vehicle under 26132. This section addresses 261(1) to 31 under the section certificate of title, and exempt these sections for previously registered vehicles unless they have been sold or a new title is issued. Exactly, like I said. So it was previously registered, not unregistered. It can't be unregistered until it's been sold or transferred and a new title is needed. I do not believe that these sections apply to your vehicle. These definitions and law make a distinction between previously registered and unregistered vehicles under certain conditions, but do not change the registration requirement under 26140. Yeah, but it also doesn't change the fact that you can't tow a vehicle under 26140. They had to use the abandoned vehicle statute to justify the towing of the vehicle, not 26140. There's nowhere in there that it says that. So he says, you may be contesting the citation with district court. For purposes of this hearing, I have no authority to determine responsibility for the charge of unregistered vehicle. My determinations must only be in keeping within the purview of 26233 as it pertains to circumstances known to the officer at the time that the decision to tow the vehicle was made, and whether or not there were sufficient grounds for towing the vehicle based on what the officer knew at the time of the tow. That's not what it's about. It's about the reasonableness of the tow, and it's clearly unreasonable if the statute that I was charged with doesn't allow for it, and you had to use an abandoned vehicle statute and let me drive away 10 miles down the road anyway. Stupid. So I will be appealing this to the district court. He said you brought up RSA 26232, reasons for removal and impoundment. An authorized official may cause the removal and storage of a vehicle if he has reasonable grounds to believe that a vehicle that is without proper registration under 26140. That's not true. He's mixing it up. He's taking one law and saying it's part of this one, and it's not. They're two separate statutes. Anyways, so you brought up Dunbarton Police Department Policy 422. They brought that policy up. They used that policy to justify. That's the abandoned vehicle policy. That's I didn't bring it up. They brought it up. Towing vehicles and community caretaking inventories, which was never done. The policy allows for an officer to cause the removal of a vehicle if it is without proper registration. You raised other issues which may be important to you, but do not impact whether or not there were sufficient grounds for the tow, and I have not addressed them in this decision for that reason. Consequently, I find that Dumbarton Police had the requisite authority and legal basis to order the towing of your vehicle on May 25th, blah, blah, blah. You may seek further review to RSA 26233 4. And so I asked them too, they're not telling me like, where am I appealing? Am I appealing this to the Supreme Court? Am I appealing this to district court? I don't even know. But I did just get this via email. They sent it certified mail. And then it got returned because I don't check my mail that often, and I was unable to get to the post office to get it. So there's that on the tow, the unlawful tow. I have the trial date on that is October 8th. So I have trial on October 8th at 8:15 in Concord for unregistered vehicle and uninspected vehicle. That will be a very long trial. Let me tell you, I'm going to have lots and lots and lots of questions for this officer, seeing as they're making me fight it all in court. And I'm still waiting for discovery on this. They're not trying to give me the body camera footage and the dash cam footage. They want me to sign a protective order that's, the judge issues a protective order. This is the prosecutor's office trying to make me sign a protective order citing RSA 105D, which is a law that governs police officers' use of body camera, not my discovery. And they explicitly mention they don't want me to publish it, which is prior restraint. It's called prior restraint. You guys probably know that. So yeah, I got this on October 8th. And then October 9th, I have the sentencing hearing for the other registration ticket that I had. And it's, then I'm going to be appealing that. It's the same argument that we're getting into here. So I'm going to be appealing that. I filed a motion to dismiss. And then, so I also had another trial, which was that contempt, right? So I got that new hearing date, and it was for October 9th as well. So I went to Franklin District Court yesterday, and I told them, I filed a motion for a new date because I have this one already scheduled. And so it'll be sometime in mid to late October that we go down that road again. I did file a ton of complaints with Justin Jordan Hazy from the Administrative Office of the Courts. I also checked up on an investigation that I had started. And Justin Jordan Hazy's like the head of the court security. And he had a guy, S. Walsh, looking into it. So I was there for a status report as well. And on that investigation, it's been like it's been like 3 months, right? So he says that, so the supervisor comes out and he says, Walsh doesn't work for the administrative office of the courts anymore. He's gone. And so he never forwarded anything about the investigation. So everything I did, sending transcripts, sending the videos, sworn statements from me and my buddy, all of that stuff just went nowhere. I just forwarded it all today to the supervisor who's supposed to be looking into it. I also went to the feds, the U.S. attorney, and I filed a complaint. That's not about the recording in court thing. That is about the misuse of the Fusion Center data, the 602 pages. I can't even remember what video a little while back that I did that has that in there, but this is them tracking and tracing in real time, 24/7 monitoring protesters' social media, even though there was no criminal predicate or anything like that. So I also talked to, it's called the Conduct Review Committee at the Police Standards and Training Facility. I am getting them this 602 pages so that they can investigate and stop this practice of, like, this is the top commanders of the different state trooper barracks, and they're using this Fusion Center data to help the governor target their political opposition. It's very, very troubling. Obviously, you guys see the political climate nowadays. It's insane. People are crazy. The left and the right, both sides are fomenting this division. I'll blame both sides. I'll blame the media. I'll blame the government itself for also facilitating and fomenting all the divisiveness and the division. So, yeah, so I'm going to be getting the video from the contempt hearing. I got to request that video. So I'm going to be doing that. And I have this packet for filing a complaint on the judge. It's a whole different, it's the JCC, the Judicial Conduct Committee. So the judge is going to get a complaint through them. So I got that to do. I got a lot of homework here. And this is my continuance for that trial. I got to mail one of these to the sheriff's department. And I also paid $35 for an audio CD from the contempt hearing. So I got that on the way. It'll be mailed to me. And yeah, I had to continue that trial. And so the plan is, you know what my plan is. I'm going again, and I'm not going to sign their stupid little notice because, number one, it is for advance notice to film someone else's hearing, not your own hearing. It's my hearing. And number two, when I was there yesterday, I have a video. I'm going to put it out soon. The clerk at the end, before I left, I asked the clerk, I said, hey, I don't see any postage, any signs that have the rule posted, the actual rule about this recording ban. Can you confirm that the signs that ban recording do not mention what the rule is, and it's not publicly posted out here? And she said, yeah, no, it's not. And she seemed to know exactly what I was talking about. So that was the day after I went to the AOC, Administrative Office of the Courts, to file all my complaints about what's going on with the uneven application of the recording things. And this is the first time in 6 years that a judge has ever jailed me for recording my own hearing. It's ridiculous. So, yeah. So got that. Cross these things off. Reasonableness results. Oh yeah, and if anybody can help with donations, please. I got donations, different ways to donate. I'm hurting. I've had some people asking ways they can help. Donations would be greatly appreciated. I could use it right now. My bank accounts are overdrafting. And so, yeah, I would appreciate any help anyone can provide. There's, monthly sign up. There's one-off donations. Anything would be appreciated. And so the phone, let's get into the phone. This might take a little minute. So we finally have, I filed that the return, the 41G motion for the return of my phone that was stolen during my trial for recording in the lobby of the federal court. And it says, here's the order. It says, order granting in part and denying in part, document 54, emergency motion for return of property pursuant to Rule 41G. Motion for hearing and sanctions as to Frank Staples. 1, denying as moot. Emergency motion, preserve evidence, prevent destruction, and objection to judicial conflict of interest as to Frank Staples. 1, for the foregoing reasons, as well as those set forth in the government's legal memoranda, documents 55, 58, Staples' motion for return of property is granted in part and denied in part. The government shall remove from Staples' phone the video, not delete, remove the video, and then return the phone to Staples. The government shall also retain a copy of the video recording in case it might be relevant in a future legal proceeding, at which point Staples can litigate whether he is entitled to a copy. So yeah, I'll be having to go down that road. In light of the foregoing, Staples' emergency motion to preserve evidence is denied as moot. It's denied as moot because he's telling them to preserve the evidence. He's basically, they love to do this. They'll basically do what you asked or tell them they're doing what you asked, and then they say it's moot, so it's denied. It's stupid. So that was Judge Stephen J. McAuliffe, right? And I also have the order here. So this is a big, long order. I haven't even been able to read it yet, so you guys are going to read it with me and hear my reaction. This is from the judge. And he says, on April, so this will kind of give you guys a full context. If you don't know what it is, go to the filming in federal court, right to record, I believe that's the playlist. It covers everything is in there. So on April 9th, 2024, Magistrate Judge Talisha St. Mark found Frank Staples guilty of the petty offense of failing to comply with the lawful order of a federal police officer in violation of 41 CFR section 102-74.385. He was sentenced to pay a fine of $100 and a non-waivable assessment of $30, which, I don't know if you guys saw my post, a collection agency called me about that because I haven't paid it, and they've been tacking on like an extra $50 every once in a while. And I told the collection agency to go pound sand, come get it in blood. So they're not going to get nothing from me. This court affirmed Staples' conviction on appeal. So this is the lower court. Staples further appealed his conviction to the Court of Appeals for the First Circuit, where the matter is currently pending. So yeah, I've filed everything. I'm waiting for a briefing schedule from the First Circuit about this appeal for the phone thing. Following his conviction, Staples filed an emergency motion for return of property and emergency motion to preserve evidence. For the reasons discussed, his motion seeking the return of his cell phone is granted in part and denied in part. His motion to preserve evidence is denied as moot because they're preserving it. And I will get it. Trust me, I will get that video. It is perhaps appropriate to begin by noting that this court's local rules provide that all persons are prohibited from photographing, recording, audio or video, broadcasting, transmitting, or televising within the Warren B. Rudman U.S. Courthouse, including the garage, basement, and ramp area. What's not mentioned there is the lobby to the complex, because it's a complex and there's an annex connecting the courthouse to another federal building. So it's not just a federal building. You're just forced to go through the court first. And U.S. Marshals agree with me on this. There's some other things happening behind the scenes. You guys probably remember me. If you watch all my videos, you'll remember me having already talked about this. So there's stuff happening with that. And local rule 83.8. So these local rules also, the scope of them is for courtroom process. So it's only inside the courtroom. It's not in the common areas outside the courtroom. So they're misapplying it that way as well. And it says, see also 41 CFR 102-74.420, providing that federal courts may, by rule or court order, prohibit the taking of photographs within a federal courthouse. Within a federal courthouse. The lobby is fair game. The lobby is fair game. And so that rule says that the lobbies, hallways, and corridors are fair game. And there's the operational readiness memo from 2018, which I've linked in other videos, that specifically says unless there's a crime being committed, then recording is allowed, and it's not a criminal act. It's not a criminal act. Recording is not a criminal act. Okay? So on Friday, September 8th, Staples and a companion, 2023, Staples and a companion, Jason Gerhard, entered the Warren B. Rudman Federal Courthouse in Concord with video equipment and began recording. Federal police officer Michael Plant informed Staples that video recording within the building was a violation of the court's rules and was not permitted. He actually didn't say that to me. He was talking to Gerhard. All right. Staples agreed to leave, but informed Plant that he would be back the following. Oh yeah, is this the day before? And planned again to make a video recording within the building. Yeah, so this was all part of my 4-stage plan. I think that was stage 2. Stage 3 was doing it, coming back and getting arrested, and then stage 4 was recording in the courtroom, which is what I did. So, according to Officer Plant, Staples said that he and Gerhard wanted to be arrested so that they would have standing to challenge the court's prohibition on video recording. What do you know about that? The men returned the following Monday and once again began video recording within the building. Again, Officer Plant informed Staples that video recording was not permitted and repeatedly asked Staples to stop. Staples repeatedly refused. That's not even what happened. He talked to Jason Gerhard. He did not talk to me. You guys go watch the video. I sat there quietly, and when he started asking me if I was recording, I didn't even respond. I didn't say anything. So again, Staples refused. He was then arrested and issued a violation notice charging him with the petty offense of failing to comply with the lawful command of a federal police officer and released. He never mentioned any court rule or anything like that that he was trying to apply. And it's only the bailiffs, the court security, and the U.S. Marshals that can enforce 83.8 because it's a local rule. Homeland Security has literally no authority when a judge is in the courtroom. So, April 9th, 2024, Magistrate Judge St. Mark held a bench trial at which Staples represented himself. During the course of the trial, Staples asked the judge to allow him to retrieve his cell phone, on which he claimed to have exculpatory evidence, including a video that he had recently recorded. False. False. I had all the videos on a thumb drive because they weren't going to let me have my phone up there. And I gave them the thumb drive, and they told me mid-trial, they said, your thumb drive, we can't get it to work. It's not working. And I said, well, I don't know what to tell you because it works on my phone. And you have a rule that says that pro se parties are allowed the same things that the prosecution has, or whoever, the plaintiff, defendants, whatever. If they have cell phones and computers, which there was a whole team of them, there's like 5 of them, with all had computers, files, all this, and I'm not allowed a computer, I'm not allowed a cell phone, nothing. And so she let me get my phone because it would work on it, and they were going to let me run it from my phone. And so she said that I wasn't allowed to record, and I told her I can't promise you that at some point I won't pick up my phone and start recording. And she still allowed me to get my phone. So it's on her. She knew what I was going to do. And so she let me get my phone. The judge responded by saying, if I allow you to bring your phone in order to stream your video, it's just going to stream the video, okay? There's not going to be any allowance for recording or anything like that, emphasis applied. After some additional discussion with Staples, the judge said, I'll permit you to bring in your phone for the limited purpose of showing your video. Once you show the video, I'm going to have you put your phone back down and move forward with it, okay? So there's going to be no recording. I just want to make it clear on that. Staples agreed, then retreated. No, I did not agree. I did not agree. So he's lying. The judge is lying 100%. And of course, if I was allowed to record, I would have the video and you guys would have already seen it and that you would know. You would know that he's completely lying about that. I told her, no promises, honey. So at the close of the evidence, Judge Mark issued an oral ruling concluding that Staples was guilty of the petty offense charged, that is violating 102-74385. As the judge was issuing her ruling, Staples became disruptive and began swearing at the judge. Absolutely, I did. The judge asked that Staples try to compose himself, to which he replied, no, I'm not fucking composing shit. Yeah, I probably did say that. I don't remember, to be completely honest. I blacked out a little bit. He then opened his cell phone and began recording in direct violation of the court's local rule and the judge's specific instructions to him just minutes earlier. When the judge warned that he could be held in contempt if he refused to turn off the recording device, Staples continued recording and said, hold me in contempt then. You want to hold me in contempt? Hold me in contempt. I mean, that's kind of what I do. Staples' profanity-laced outburst continued, and the judge asked the court security officers to remove him from the courtroom. As Staples was being escorted out, one of the officers, it is unclear from the audio recording of the proceedings exactly who, one of the officers, it was the fucking witness in the case, Michael Plant. It was the DHS officer who he stole my phone out of my hand. He didn't have any judicial authority. The judge didn't tell court security to fucking confiscate my phone. And he's not court security or U.S. Marshal. He was a witness in the case there in his personal capacity. According to Staples, so there's a footnote. According to Staples, federal officer Michael Plant confiscated the phone. But in an affidavit submitted in support of the search warrant application, Plant testified that another officer took custody of the phone and then gave it. So this is why I'm going to need the video. The video will show Plant snatching it out of my hand and then holding it. That's how I'm going to get the video. So they already gave me the key right here. Then he gave it to Plant. Precisely which officer sees the phone is not a material fact. Yes, it is. So they're saying another officer grabbed it and gave it to Plant. Get the fuck out of here. All agree that Staples' phone was seized by an agent of the federal government and is currently in the government's possession. Yeah, all agree. All will agree with that. 2 days later, the government sought and obtained a search warrant authorizing it to search the contents of Staples' phone for evidence of potential crimes, to include failure to comply with the lawful order of a federal police officer, disorderly conduct, prohibiting recording within the Warren B. Rudman courthouse, and contempt of court. Warrant application. See United States v. Samsung Mobile, number 24MJ68AJ. 24MJ, where is it? Yeah, right there. Right? I haven't even seen that. Never got notice of it. It was against it was a case against my phone. Like how anyways, so according to the government, a forensic analysis of the phone identified the unlawful recording that the defendant made in the courtroom at the conclusion of his petty trial. Response to motion for return of property at 2. Staples seeks the return of that phone in an order of the court enjoining the government from destroying any digital evidence stored on it. The government has agreed to return Staples' phone to him, but seeks court authorization to delete the video recording Staples made during his bench trial before Magistrate Judge St. Mark. In support of his motion seeking the return of his cell phone, Staples invokes Rule 41G of the Federal Rules of Criminal Procedure, which provides that a person aggrieved by an unlawful search and seizure of property or by the deprivation of property may move for the property's return. The motion must be filed in the district where the property was seized. The court must receive evidence on any factual issue necessary to decide the motion. And they haven't. They didn't hold the hearing. I asked for a hearing, and it is a material fact who took the phone out of my hand. What if it was not a federal officer who took the phone out of my hand? What if it was a fucking reporter? What if it was anybody? It wasn't court security, it wasn't a U.S. Marshal, but somebody took it out of my fucking hand, and that's called theft, especially if it wasn't court security or U.S. Marshal. If it grants the motion, the court must return the property to the movement, but may impose reasonable conditions to protect access to the property and its use in later proceedings. So you're going to keep my evidence? Unbelievable. So the seizure of Staples' phone was lawful. According to Staples, his phone was seized in violation of the Fourth Amendment. It was not. That's it. It was not. Assuming, as Staples claims, Federal Officer Plant seized the phone after Staples began recording the courtroom proceedings and refused to stop, despite how the fuck did they know I was recording? Nobody knows I was recording. They didn't know I was recording until, like they said, they got the video off of my device. And it's not a fucking crime. It's a local rule, which is not a crime. It can only be contempt, just like we had in the state court there in Franklin District. It can only be contempt by the judge in the moment, but she didn't say I was held in contempt. She didn't seize the phone. Despite unambiguous directive from the judge, such a warrantless seizure was entirely consistent with the Fourth Amendment. Yeah, it's warrantless. He even says it's a warrantless seizure. As the Supreme Court has noted, it is, of course, an essential predicate to any valid warrantless seizure of incriminating evidence. What's the incriminating evidence? That the officer did not violate the Fourth Amendment in arriving at the place from which the evidence could be plainly viewed. There are, moreover, two additional conditions that must be satisfied to justify the warrantless seizure. First, not only must an item be in plain view, its incriminating character must also be immediately apparent. Immediately apparent. Not requiring a search to determine that there's a video on the phone that's not breaking any law. It's not recording anything restricted or anything. It's pretty mind-boggling. So he's saying Horton v. California, 496 U.S. 128. See also United States v. Gamache, 792 F3D 194 in the First Circuit. As we have explained, the plain view doctrine permits the warrantless seizure of an item if the officer is lawfully present in a position for which the item is clearly visible. There is probable cause to seize the item. And you probable cause. You need to know for a fact that I'm recording. And the officer has a lawful right of access to the item itself. And they don't have a lawful right of access. He was not a court security officer. Anyway, here, each of those three prerequisites to a warrantless seizure was plainly present. Officer Plant was lawfully in the courtroom at the time of the seizure. He witnessed Staples recording the proceedings in violation of the court's local rule and magistrate judge's specific order to stop recording. The phone then contained evidence of Staples' unlawful conduct. It was in plain view, and Officer Plant had the authority to collect that evidence. The subsequent forensic search of Staples' phone was entirely consistent with the scope of the warrant obtained by the government 2 days later, and, despite Staples' claim to the contrary, neither the process employed to obtain the search warrant nor the subsequent search of his phone deprived him of due process. But, says Staples, that video recording is important evidence in the pending appeal of his criminal conviction, an unrelated 1983 suit that he has a pending violation against various New Hampshire officials, and prospective criminal complaint regarding the seizure itself. Yeah, it's theft. It's evidence of theft from whoever stole it out of my phone. If they're saying it wasn't Plant, that somebody, so that's receipt of stolen property. We need to know who took the phone out of my hands, because could have been somebody in the pew. It could have been a prosecutor. Prosecutors sure as shit don't have the authority to take the phone out of my hand. So, Um, even assuming, what is he saying? Indeed, one reason the government is willing to return the phone is because it is not relevant to Staples' pending appeal. So if it was relevant, they wouldn't give it back to me, they're saying. Oh my God. But even assuming the video does have some potential relevance in other proceedings, that does not undermine or even call into question the validity of the original seizure of the phone. Yeah, I know. These are called conclusory statements by the judge. Staples is not entitled to the return of that video. The video recording at issue was created, and here's something else. No charges, and they're not going to charge me. So if it's evidence of a crime, why haven't I been charged with anything? And why won't I be charged with anything? So you want to keep this illegal evidence and you're not even going to use it and it's supposedly criminal? Come on. So the video recording at issue was created in violation of the court's local rules and in violation of the court's direct order that Staples not use his phone to record any aspect of the trial. So what does that mean? That means the judge could only hold me in contempt, which she declined to do. She neglected and declined to hold me in contempt. So there's nothing they could do unless the judge holds me in contempt and orders the phone to be seized in the moment. And they didn't. She said, leave. And they said they would give it back to me outside. They said, I'll give it back. We'll give it back to you outside. And then that's how they got me to leave without it. And then they kept it. So, the video then is contraband, and the government is legitimately concerned that Staples will post it online. Oh, prior restraint? Prior restraint, anyone? As he has apparently done with other videos taken within the courthouse. Oh, no! Accordingly, the government may properly remove it from Staples' phone before returning it to him. See United States v. Perrette 484 F3D 75, First Circuit, 2007. A Rule 41G motion is properly denied if the defendant is not entitled to lawful possession of the seized property, the property is contraband or subject to forfeiture, or the government's need for the property as evidence continues. There's none of those. There's none of those. Citations and internal punctuation admitted. See generally United States versus Droganis, 728 F3D 580 6th Circuit. That's not controlling. Noting that individuals have no property interest in contraband. It's not so the video is contraband, is what they're saying. Even though they don't have the video, I would have been able to get the video of the hearing. I would have been able to, but they don't have it. They lost it or destroyed it. But I wouldn't have been prohibited from getting the video from them, paying to get it from them. But I'm not allowed. It's contraband when I make it myself, when I create my own records. Nevertheless, the potential relevance of that video recording, no matter how slight, in future proceedings, including perhaps Staples' own trial if he is subsequently charged for his unlawful conduct at his earlier trial, counsels in favor of directing the government to preserve a copy of that video for possible future use. See Federal Rules Criminal Procedure 41G, providing that the court may impose reasonable conditions to protect access to the property and its use in later proceedings. Conclusion, finally, geez. As noted above, the government is ready and willing to return Staples' phone. Well, it's been at this point like 16 months now, since they stole my phone. So it's been a long time coming. It seeks only authorization to erase the video recording, and they only sought that after I tried to get the phone back. They then try to say, oh, we want to delete it before we give it back to him. Why didn't they file something immediately saying, we want to delete this vid off his phone and get him his property back because we don't need it for anything else? No, of course not. No, they just wanted to keep it forever and hope it goes away and that I forget about it. Before the phone is returned. And as noted, Staples is not entitled to the return of that video. It may then be properly erased from Staples' phone. Nevertheless, the government shall retain and store a copy of that video in case it should prove potentially relevant in any future legal proceeding. For the foregoing reasons, as well as those set forth in the government's legal memoranda, documents number 55 and 58. Staples' motion for return of property, document number 54, is granted in part and denied in part. The government shall remove from Staples' phone the video recording of Staples' trial proceedings that was created on a. It's like I'm entitled to it, but they got rid of theirs, so they want to keep mine. The government shall also retain a copy of that video in light of the foregoing, blah, 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 blah. So I'm going to get the phone back sometime. I'm not sure. They're not really. And I also want a log. I want a chain of custody and inventory log of everything that they searched. I want to know what programs they used to search, how deep they went into my phone, all that stuff. I want a full inventory report and forensic, analysis of what tools they used. So we're not done yet, folks. We're not done yet. But that is the latest update. And like I said, the charge itself is on appeal in the First Circuit. I'll do a separate video on that to get into the arguments, some important jurisdictional arguments there. Boom, reasonableness, phone return, candlelight vigil, and all that. So, all right, so we got this. Let me check the chat too. Never forget the government. They're falling. Yeah, the government is falling. Well, Rob Diva, what's up? Ali Bell, Deaderex, greetings and salutations. Spring Cheetah. I look like Jim Carrey. I get that sometimes. Corruption of people's sovereignty. So seem like you've probably been here for a little bit. So that's basically, there's multiple issues going on here. I've been filming in the courts here and not, filling out their permission slip. It's an advance notice for my own hearings because I don't believe I have to when it's advance notice. It can't be denied, and it's for recording someone else's hearing. So that's been a project of mine. I've also been attacking, like I said, in the federal court. I had a scheme to get arrested in the lobby of the federal court here in New Hampshire to then get the standing to challenge it in court, which I'm doing. I've been doing now for, this case has been going on for 3 years about. Look like someone who maybe. Johnny Bravo, what's up? Yep. Nope, not signing shit. So, Constitutional Freedom Fighter, what's up? Charlie Kirk. Yeah, the whole Charlie Kirk thing is insane. Obviously, I don't support any of that type of stuff. I have my own opinions. I don't agree with everything Charlie Kirk said. But I agree with a bunch of things that he says. Like everybody, I agree and disagree, and I don't think we should be killing each other because we disagree with each other. And that was coordinated. That whole thing was highly, highly coordinated. 100%. It's a conspiracy theory. Yeah, I know. There's a lot of stuff going on. There's probably going to be a few more of these things that happen, and then at some point they'll declare martial law, and then they're going to come around. They'll put National Guard out. Once National Guard's in position, they'll start going door to door to collect everybody's guns. So all of this political rhetoric from the left and the right, you're both to blame. The media is to blame. Our elected officials also are mostly to blame. Not all of them, but the vast majority of them have fostered and fomented the division. It's disgusting. And Kash Patel, you know who his girlfriend is, right? So Charlie Kirk also, he was a staunch advocate and supporter of Israel, but then he's recently called it a genocide, and he's also, thanks Bob Bobbing, I appreciate that. He said sweet beard, but what was I gonna say? As of late, Charlie Kirk has kind of changed his tune on supporting Israel and demand for the Epstein files to be released. And he's too big of an influencer to have the conservatives start getting on the watermelon boat, if you know what I'm talking about. Brandon Mitchell, what up, brother? Green Light Chronicles, JB. So these are kangaroo courts. We have kangaroo courts, absolutely. They all got the gold fringe. Scarbs, hello to Serbia. Hello from New Hampshire. So they broke my Fourth Amendment right, absolutely. Many times. Angler Emma, what's up? Most judges don't know how to do their jobs. Many are appointed and have no legal experience to support qualification as a judge. The judge on feelings, not facts. Yeah, I mean, you guys, I'm going to get the audio. Where do you hear this guy from the contempt thing? So I get charged for contempt for not signing the notice. Then during the contempt hearing, he says, oh, you were disorderly earlier and you just told me fuck you just now, which should have been separate contempt charges. Those are separate contempt charges, and you can't bring anything into a contempt charge that isn't what the charge is. And so he totally violated, my Fourth Amendment rights. That was an illegal seizure, absolutely. Tampering with evidence. Yep, that's what they're doing. They're tampering with evidence with my phone. It's crazy. So how'd they get into it? Yeah, it was locked. They used some sort of, that's what I want to find out. I want to know, what did they use? What program did they use? Did they get a warrant and then bring it to Samsung, and then Samsung gave them a back door? That's another piece of this that I want. I don't just want my phone back and the video, which I will get. I'm getting the phone without the video, but they have to preserve it, which is fine. That's fine. I'll get it. Boom, boom, boom. Yeah, Bob Dole. I wonder how many people. Yeah, see you later. A demon ran behind you, probably. Never forget Building 7. Never forget Building 7. How about that? And now, the watermelon boat. Yeah, you know what the watermelon boat is, G Squizlet. Come on. The watermelon. That's the Palestine supporters, the watermelon. It's because their flag looks like a watermelon. So yeah, let me continue on. I just wanted to catch up on the comments there. This one's not as long. It's not as long, but this is about the 1983 lawsuit for all the arrests that you see on my YouTube during COVID and the events that took place during that time period. And what's happening, this will kind of give you a rundown of the entire situation. I did file, because I have this 602 pages of Fusion Center data that I want to submit in order to get us into discovery in this case, because the Fusion Center data that we have is part of the complaints that in this case. So this is an order and report and recommendation. Self-represented plaintiffs Frank Staples and Kathleen Boussier filed their first amended complaint, Doc 48, on April 10th, 2025, which added new defendants. There's a footnote. The original complaint named the following defendants, all of whom were served: New Hampshire's Governor Kelly Ayotte and Attorney General John Formella, Christopher Sununu for his individual capacity claims, Charles O'Leary, and a series of John Doe defendants who are law enforcement officers, substituting the current Governor Kelly Ayotte with former Governor Chris Sununu for plaintiff's official capacity. They have that switched. I don't know who wrote this, but I served Governor Sununu. Then he left office and Kelly Ayotte came in and she assumed, so they have it backwards. The judge is totally flipping things around because she doesn't know what she's talking about. The defendants that were added in the plaintiff's first amended complaint, but as of this date, the order, report, or recommendation, plaintiffs not served are New Hampshire State Police, Town of Newfields Police Department, New Hampshire State Troopers Megan Walsh and Gregory DeLuca, the estate of Kathleen O'Brien, former Newfields police officer. That's where we got the 602 pages. And a series of John Doe defendants who are either government agents, law enforcement officers, or officials whose identities are unknown. Another reason why I need discovery. Defendants and Defendant O'Leary together moved to extend the time to respond to the plaintiff's first amended complaint. Yeah, so they were in default. They were already in default on the other one. Then they were in default on this one and tried to ask for more time. Plaintiffs did not object. We did object. Instead, plaintiffs moved for entry of default and for default judgment against the state defendants. That is an objection in and of itself. Defendants object to plaintiff's motion for default and default judgment. For the reasons stated, the court grants defendants' motion to extend. So they gave the criminal state agents more time to respond and recommends that the district judge deny motion for entry of default and default judgment. Defendant's motion to extend. As an initial matter, plaintiffs did not file an objection to the defendant's request to extend time to respond to the plaintiff's amended complaint and therefore waived any objection to that motion. That's bullshit. We objected. We absolutely objected. Despite plaintiff's waiver, the court nevertheless concludes that defendant's extension request is warranted. Provides that, so Federal Rule of Civil Procedure 6B provides that when an act may or must be done within a specified time, the court may, for good time, extend the time. I mean, they've been extending these people's time. They've been getting all these extensions, and not doing any discovery conferences or anything. Let me get some water. Oh my God. So blah blah blah. Here, defendants time to move to extend. Defendants show good cause for their extension. Plaintiff's motion for, so, you know, basically, for the reasons stated above, the court grants defendant's motion to extend time to answer and recommends that the district, blah, 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 deny our motion for default judgment. Any objections, the court. Anyways, so yeah. So they get all the time in the world. And, now pending, there's some pending motions which you guys have seen me file. I believe I linked the filings in the comments, the late night Dropbox videos. Go check the late night Dropbox videos. And we're talking about a bunch of stuff. If you look in the description of the video, it kind of gives a little rundown of everything we've been covering, basically covering the entire channel and where we're at right now with all the different cases and where we're going with the future trials coming up and pending motions. So yeah, we have some pending motions here on this lawsuit for the unlawful COVID arrests, and I'm trying to get the judge to allow me to submit the 602 pages of Fusion Center data that proves the conspiracy. There's an email that shows an agreement between state police, the Fusion Center, and the governor's office to target peaceful protesters that were not planning anything violent, no threats detected, no criminal activity, and they set up arrest teams, tactical units, for 8 people that were planning to have a candlelight vigil. So I planned a candlelight vigil in, was it 2020? I think it was 2020. And yeah, they were waiting for us. They were monitoring social media. Despite no threats detected, they had arrest teams prepared. They planned to use disorderly conduct, which is exactly what they ended up doing that night. Not on me, but somebody else. They ended up pulling the disorderly conduct stunt on me later. And so this email, I believe I posted it here as well. There's one sentence that's redacted, but this is from Lieutenant Hennessy, the commander of Troop A. And he says, let's not enforce the town ordinance. Let's just go with our original plan to use the disorderly conduct statute, which we seem to have mastered. So they're masters of applying disorderly conduct against peaceful protesters, apparently, is what the email says. I'll go check if I remember after this, and I'll post it again, or I'll post it if I didn't post it. But yeah, so that's basically it. I'm trying to get into the discovery. I'm trying to get the other years, because there's like 3 more years of Fusion Center data that they must have, and all the way up to the 9 arrests, which is what the lawsuit started with. But then there's a pattern that goes all the way back to 2020 through 2021 of the government using this stuff to track and trace the opposition of the sitting governor. So that's what's going on, and that's what our government is using with these Palantir stuff and the Fusion Center data that everybody loves. So if you're on the right and you love Trump and you support Peter Thiel, the Epstein's buddy Peter Thiel, and Palantir, and the tracking and tracing of everything you do, the mass warrantless surveillance and searching of American citizens, then I don't know what to tell you. I'm not having it. I'm not for it. And it's $1,000 fine for every misuse occurrence of this Fusion Center data. So I am, like I said, I did go to the U.S. Attorney. I filed a complaint a couple days ago. I'm still waiting for a call back on that. And we'll see what we could do. I have the Conduct Review Committee, which is a board of state reps and citizens, regular New Hampshire citizens, and law enforcement, who are going to review all of the proof that we have that the Fusion Center data is being misused. And I'm sure it's not just here in this state. I'm sure it's just not here in the United States. This stuff is being used all over the world to a degree. And yeah, people need to be aware of every comment that you make. You better believe every comment that gets made on my videos gets swept up in the dragnet. And if you say something crazy, you're probably going to get on a watch list, and then it will spider out, and it will look at everything connected to you and every post that you make and made. It can go all the way back in time. So be careful out there, and be careful what you say. And I hope that people on both sides really try to come together and stop with the finger pointing and the blaming and the idolizing and the demonizing of people, and just try to be a little bit more objective about the world and what we got going on here. So yeah, that's basically it. If anybody has any questions, I've been going nonstop here for just about an hour. I think I covered everything. Oh yeah, and if you guys, I forgot to link it. Let me write it down. The Telegram group. I've had some people join in the Telegram group. Easy way, direct line of communication. There it is. And I will go link it in the description right after I shut this off. Let me flip back here. I will ask you guys questions before you join. You got to respond. There's like a bunch of people that haven't responded to my query, and you're not getting in if you don't respond because you're probably a bot. So, Lion's Den. I call it the Lion's Den, but it says I speak with my feet, so you're gonna have to do a join request. I'll send you a message, and you give me your response, and you can get in the Telegram group. Lion's Den link. All right. So I'll do that. And again, if you guys are still here, please consider, if you can't, don't donate or sign up. But if you can, I would really appreciate it. It'd be helpful if you could sign up for my monthly thing, $1 a month, $5 a month, whatever you can afford. There's a couple people doing 15, and it is very helpful. It's all going. It just went to my bank, which is negative, so it's going to just take care of that a little bit. And yeah, if you want to do a one-off donations, there's stuff down there, PayPal, Venmo, all that. Appreciate you. I will upload. I have a whole bunch of stuff. I don't have room on my phone, so I got to shift some things around to be able to get all of the videos off of my DJI and then stitch them together, upload them, remove them, do the next ones, and I'm super backed up, not just on legal work, but I'm backed up on all of the videos, and I have to put them out in order of occurrence so that people have the full timeline. But yeah, I have a whole bunch of stuff from the past 3 months that I've been waiting to put up, in, for when it was finished, and much of it's finished. Oh yeah, that's the one thing that I forgot. So I was representing, some of you may remember, I was representing a guy in court, a friend of mine, for a civil harassment petition that his neighbor brought against him, and all kinds of issues with that. It turned into like 6 hearings, and on the 6th hearing, I ended up being removed from the case because of the contempt, because it's the same judge. And so he removed me from the case, and all we had to do is cross-examine the police officer. So I had already done all the cross-examination of the Karen. You guys will see that. It's really quite embarrassing. And so, yeah, I wasn't able to finish that case, but I did get it, I got it to the end zone. I got it right on the freaking the 1 yard line. And so my buddy ended up taking it home, and I don't even know what happened with it. I haven't talked to him about it. But yeah, had a lot of stuff going on, and that's basically it. So thanks, everybody. I'll go through. No awful orders. That's right. No awful orders. Hello from London, England. Hello. Shout out from across the pond. Excellent. Yes, Desk Mouse. I'm like a pit bull crossed with a gadfly. Wizard Harry, class action against Gillette, broken razor. Got some jokers in there. All right, everybody. That's it. Thank you so much, and I'll see you guys soon. Yeah.